Hi, good afternoon if you're on the East Coast, and good morning if you're out west. My name is Aaron Lacey, and you are listening in to Advertising and Communications for Institutions of Higher Education, which is part of the Higher Education webinar series that our law firm has been putting on. Thompson Coburn, by the way, is the name of the law firm. We're based in the Midwest and have offices on all the coasts and all those big cities. Really delighted for everyone to be on today. At the top here, I'm going to go ahead and go through some housekeeping, and then we will move on to the presentation. So this webinar, like all the webinars that are part of our series, is accredited for CLE for 1 hour of general CLE credit. We have created some polling questions during the presentation that will pop up. They're not complicated. It really just requires that you click to show that you are still sitting in front of your computer screen. But if you are an attorney and you are dialed in part for CLE, please make sure to watch for those little pop-ups so you can click on them and get your credit. At the bottom of the screen, you're going to see multiple application widgets. All of these widgets are resizable and movable, so feel free to move them around and get your desktop set up the way you like it. You can expand your slide area or maximize it to the full screen if you prefer. If you have any questions during the presentation, we want to try to get to them. Please submit them through the Q&A widget. So you can type them in, and then when we get to the end of the presentation, we've allotted a little extra time, and we'll try to get through as many of those questions as is possible. A copy of the slide deck. We always get questions about where can we get a copy of the presentation. And by the way, if you can't find it, you can always email us, and we'll send you one. But there is a copy of the slide deck. It's in the resource list widget that's available on the screen. There's an on-demand version of the webinar that will be available usually by the end of the day. That's one of the things we like about this platform, but if not, tomorrow, so that you can go back and listen to the presentation if you want to pass it to a colleague or just hear it a second time, and it will be hosted on our website. So they are free. All of our presentations that you see up here that we've done previously are free and on demand. There's another slide that looks almost exactly like this one at the very end of the presentation, and it has some live links. And you can click on those in the PDF version of the presentation, and it'll actually take you to our website where those are available on demand. So today, our presenter who's going to be joining us is Mr. Mark Sableman, and I want to tell you, I'm really excited about this presentation for 2 or 3 different reasons. The first is Mark. You can see just a couple of bullets here about Mark's bio on the screen. He is truly an intellectual property, media, and information technology law guru. He's an expert practitioner, has been in the space a long time, but one of the things that I just wanted to highlight is, you hear people talk about this notion of a thought leader. I mean, Mark really is a thought leader in this space. He's written a book, More Speech, Not Less, Communications Law in the Information Age. He writes a great deal, a number of law review articles and other things that are in all the different types of publications you'd expect them to be in. And some of his articles and writings have won awards and been recognized for their quality. The other reason I'm really excited to have Mark is because he does a lot of speaking, and it's always nice if you're going to listen to a webinar for 60 minutes to have somebody who knows their way around a presentation, and Mr. Sableman is one of those guys. So very pleased to have him here today. The other 2 reasons I'm very excited, I think in general, any type of conversation around new media and communications and digital media tends to be very interesting, and we like to have interesting topics. But third, and probably most importantly, is because this is such an important topic, and Mark and I were talking about this a few minutes ago before the presentation. We work with institutions in all sectors, and there are certain sectors of higher education, particularly I think among some of the career schools, that have engaged in what I'll call sort of traditional commercial marketing for a very long time and have a lot of familiarity with the kinds of things that they do. But among institutions, what I'll call traditional institutions of higher ed, so our private nonprofit clients and our public clients, what we have seen, particularly in the last 5 to 10 years, is a real evolution in their approach to marketing. For a very long time, and many of you know this to be true, if you look back 80s and 90s, even the early aughts, traditional institutions of higher ed typically had a limited number of marketing channels that they stuck to, and for the most part, they didn't engage in a lot of what I'll call progressive or aggressive marketing. And that has really changed. The competitive landscape has changed. The types of marketing that are available to institutions of higher ed. There are lots of ed tech vendors now that are very interested in selling our clients' platforms. And as our traditional institution clients tend to move more into those sort of new media and progressive types of marketing, they are being faced with regulatory frameworks that are new to them as well. So we got a great presenter, we got an interesting topic, but I also want to highlight, if you are out there and you are thinking about some of these things, if you are thinking about engaging a new vendor or one that is new to you to provide you with some sort of marketing support or analytics, please be aware that there are a lot of sort of regulatory and legal issues that you need to be aware of and paying attention to. So with all of that having been said, I will pass it over to Mr. Sableman.
Well, thank you very much, Aaron. I'd like to point out for the record, everyone, that until 2 or 3 minutes ago, Aaron, I consider a really good friend, but after he set really high expectations for me, I'm not so sure about that. But
no pressure. No pressure.
But he did lay out, why this is important, which I think is a good thing. Obviously, there was a time when higher education was kind of above it all, but now you're in the fray. Digital communications and advertising affect you like it affect everybody in our society today. So it's really important to get a grip on these issues. I can't cover everything in this field, but today I'm going to try to cover these 5 topics: the legal principles of advertising, endorsements and influencers, the highly important issue of today in social media, use of social media photos and other content, which is the number one area I see people getting into a lot of trouble on, and you really need to reinforce this message because it's so hazardous these days. Use of movies, which I think is important to people who are often out in the field trying to give presentations and keep attention, and you'll see that this is an issue that there's actually kind of a key to how to do it and not infringe anyone's rights that very few people know about. I want to talk about that. And finally, user-generated content. What do you do with content that other people put up on a website under your control? There's some really special laws that you need to know about on that. All right, so let's just move into general advertising principles. It's pretty simple. Advertising, marketing, anytime which you're promoting yourself or your business, you have to be truthful in your claims. The claims will be understood in full context. The statements can simply be true in some abstract sense, but not true in the way they're presented, because everything in advertising law is viewed through the eyes of the ordinary viewer. And that's the mantra you'll hear me returning to again and again. How are things understood by ordinary viewers? Now, I think there's some misconceptions about advertising law, and part of it is because the environment we all live in, we see these political ads that are often deceptive, out of context, tricky. I love this full-page ad from the New York Times that ran actually in ancient times, I think in 1992. And Ketchum Advertising in New York took out that ad and said, "Don't call it advertising," pointing out how political ads are so far afield. No matter what your politics, you must be appalled at the political communications during this dirty election. And that was one many elections ago. I'm sure they would say the same thing or more these days. And they wanted to take out this full-page ad today. This is not advertising. If a reputable corporation produced advertising with the same exaggerated claims and promises for their products and then failed to deliver, those executives will be fined or let off to jail in handcuffs. And that is true. The standards for commercial advertising, for basically anything other than political advertising, are very strict. You've got to have truthfulness in context as understood by viewers. It's essentially a strict liability standard of truthfulness in context. It's enforced in a lot of different ways. The Federal Trade Commission is the federal agency charged with combating unfair trade practices. While it's a small agency with a limited staff that can hardly police all of national advertising, it does focus on areas of great importance to the public. And in the past, that's been things like automobiles, car rentals, products that digital communications products, internet services. But obviously, higher education and is one that's caught their attention, and the FTC enforcement is a very significant concern in your area. Then there's private litigation through Section 43A of the Lanham Act, essentially the federal law of unfair competition that prevents false or misleading claims, commercial claims, in as to your own or another party's products, services, or commercial activities. And then finally, there's the National Advertising Division of the U.S. Council of Better Business Bureaus, which is the advertising industry self-regulation process, which has a kind of private arbitration process that it's often wise to pursue if there's a dispute between two entities. So those are the kind of the procedures. But under the Lanham Act in particular, and under the FTC laws, everybody along the line is subject to liability. The advertiser, the entity whose products or services are being advertised, is liable. So is the advertising agency along with its client. And so are endorsers, and we're going to get to this a little bit more in this endorser-influencer discussion. But anyone who is part of the advertising, including the endorser and the agency, has potential liability. Now, let me give you a couple of examples from business litigation, business advertising, of what the standards are. This is an interesting case was just litigated a year ago about a vacuum cleaner comparison. And the company that was selling the vacuum cleaner illustrated with the red column was saying, hey, we deep clean carpets, plural, better than the $600 Dyson. And they showed this chart showing they get more dirt off the ground, off the carpet. It looked great. They claimed it was an independent test. But as a matter of fact, it was an internal test, not an independent test. It didn't use settings that were consistent with what the manual said. So it really wasn't a fair apples-to-apples comparison. And they overstated their claim, saying all kinds of carpets was, in fact, only one type of carpet was cleaned. Well, these were all, I guess we might say to some extent, nuances, but together they added up to a significant misimpression to the consumer, and they led to a $16 million verdict for this kind of false advertising. So what that tells us is you've got to be especially careful whenever you're making comparisons. They've got to be apples to apples. They've got to follow the proper rules. They really ought to be truly independent. Whenever you're discussing metrics, we all know that there's three kind of lies, damned lies, and statistics. As Mark Twain pointed out, metrics can be very misleading. So you've got to have the independent verification and the objective use of metrics in a way that is not misleading. You've got to take care, obviously, of your terminology, whether it's carpet or carpets can make a big distinction. And in all of these situations, again, we go back to this basic mantra of advertising law: consider the reader or listener or viewer's normal understanding. You cannot sit in a courtroom and say, technically, if you look at the dictionary, this was correct, because it's the average consumer's understanding that's going to govern the case. Now, here's another thing I think is important. There's always a question in advertising: is your claim factual or puffery? And we use this illustration as it's kind of a good example. America's favorite pasta. Maybe your favorite, maybe not my favorite. How do you determine whether someone's favorite? Courts view this as a case of a situation of puffery or opinion. You don't have to verify that. Again, the feeling is the average consumer will view that as merely a puffing, a broad claim where there's no factual support for it. But then on the issue, on the other one here, Splenda, it tastes like sugar. Well, that's a factual claim. You can objectively verify whether something tastes like sugar, so they cannot get out by saying this is just our claim, our puffing. They've got to have factual basis, credible factual basis that it truly tastes like sugar.
So, Mark, can I ask you a question? On the prior slide, just before we get too far down the road, you were talking about metrics, and we've talked about in the context of higher education the types of metrics in a comparative marketing campaign that could be problematic. If you're trying to say, you have 5 or 6 institutions, for example, that you show, and you're trying to compare their tuition or their tuition discounting or their financial aid or something like that. I mean, are those the kind of metrics we're talking about that could get you into trouble?
Absolutely, because there's so many different ways to pick your comparison. And let's say you don't disclose the names of the other institutions, but say, hey, we're so much better in this way, our graduation rate or our tuition or our scholarships. Well, if those aren't truly apples-to-apples comparisons, that's misleading. There's all sorts of things that can be done with metrics that are problematic. So you've got to have a lot of vetting of ads to have that kind of claim.
Got it.
And then I'm puffing, just for anybody. Again, look at your tagline, your model, your slogan. Is it a puffing or is it a fact claim? Look at all your promotional copy. You want to be sure that you're, properly classifying them, because if it's a fact claim, you've got this obligation to verify it. And here's an interesting example. It just came up. Miller Coors is suing Anheuser-Busch right now. Their Budweiser ads that claim Miller's beers are made with corn syrup. Well, Miller says, yes, we use corn syrup in the process of making our beer, but corn syrup is not present in the final beer. So it's a classic advertising case. In this particular case, the facts are absolutely clear. We know what Miller does. There is corn syrup used in the processing. We know what Budweiser claims. Miller's beers are made with corn syrup. The real issue is, what does the consumer take away? When the consumer sees the phrase up on a billboard, made with corn syrup, do they conclude corn syrup in the final beer? Do they conclude inferior? What do they conclude? That's going to be the test of the entire case. And again, it illustrates my underlying principle. You don't judge this thing by the dictionary. You judge this by consumer understanding. It frequently takes consumer understanding surveys with very sophisticated survey experts. We've done many of them, but that's what's involved in advertising substantiation and verification. All right, new subject now, endorsements. What about this new world of endorsements? Well, just to illustrate what a new world we're in, think about the old days. And by old days, I mean anything before 1995. That's my cutoff as an internet digital communications lawyer. In the old days, you had things like Joe DiMaggio endorsing Mr. Coffee. You'd see magazine ads, you'd see TV commercials, and there was Joe saying Mr. Coffee is the greatest. Everybody knew that Joe was endorsing him. Everybody knew that Joe was paid by Mr. Coffee. There wasn't a whole lot of doubt there. But modern endorsements occur on social media. There's gazillions of them out there every day. So the Federal Trade Commission had a rule on endorsements, but it was geared to the old ways of celebrity and professional endorsements, and assumed that everyone would see when there was an endorsement. The only question is, were they being accurate? Were they being honest? Those were requirements. So the new FTC rule a few years ago said, actually it was designed for a new technology of the day about 10 years ago. That was called blogs, before the new technology of social media, essentially. But they said that statements in blogs could be misleading because we don't know if the blogger is paid or got something of value from the advertiser. So we need to know if the blogger in some way was connected to or controlled by the advertiser. So the FTC tripled or quadrupled the size of an endorsement rule, gave all sorts of examples, and said, from now on, social media, blogging endorsements are subject to these rules. One of the first test cases came out with Cole Haan, the shoe company. They had a contest in which they encouraged customers to post 5 images of Cole Haan shoes on Pinterest. Well, they were going to award $1,000 to certain of the people who posted that. So it looked like on social media there was an outpouring of people who said, wow, I love my Cole Haan shoes so much, I'm going to post pictures of them. Well, in fact, they loved their chance of getting $1,000 so much they posted those. So it was misleading, and Cole Haan was sanctioned. The consumers' pins didn't make it clear they'd been posted in hopes of winning a contest. Here's another one. This machinima campaign for Xbox games, the company paid for reviews but didn't disclose the payment. So again, the FTC charged them and said, these reviews do not reflect the independent opinions. You failed to disclose the fact that they were compensated. So this all goes back to the specific rules that are in the endorsement rule. Messages have to disclose if there's cash or in-kind payments made. The material connections have to be disclosed. So here's the language. I've taken the language in red is straight out of the FTC rule. So the real issues are, if the audience thinks that what you say reflects your opinion as a release, and you have a relationship with the company marketing the product, it's an endorsement. At any time you're given something of value that might materially affect the weight or credibility of your endorsements, you have got to disclose that. So what kinds of relationships? Pretty much anything from receipt of sample products to anything more. So anything where you've got an advantage over members of the general public in connection with this company, you have got to disclose. Now, again, the rule was written in the sort of ancient days before social media took over the world. So they gave examples of blogs, and they said in a blog, all you have to do is say, Company X gave me this product to try. Doesn't have to be long legalistic. Don't have to hire the most expert lawyer in the world like Aaron Lacey to write the disclosure statement for you, but a simple statement like that works. So the FTC thought they'd taken care of it, but of course the FTC hadn't anticipated the newest technology, social media, and people think in social media, particularly Twitter, that is far too many words. That's 7 words. How can I use 7 words in my Twitter? So the FTC says you can use shorthand notations. Initially, I think they preferred hashtag sponsored and hashtag promotion, but nowadays, hashtag ad has become common. And people cannot protest that they don't have 3 characters. They better have 3 characters to use or hashtag ad. But it's got to be that. It's got to be something that clearly says ad, sponsored, promotion. What you have a lot is people trying to skirt it. They say, well, thanks, Procter & Gamble, or hashtag partner. That doesn't work. That may suggest something different to the average consumer. It doesn't suggest that you're getting paid or compensated. In Instagram, which seems to be the hot issue of the day, it's got to be in the first 3 lines because those are the only lines that are visible on Instagram until you click more. And you can't hide the disclosure so that only people who click more see it. All right, so that's all on social on influencer. Now, yet another topic, social media photos. And again, the reason I'm going over this is it's an issue that we see again and again, that clients are confronting it. Many clients misunderstand the issues. Many times clients, the in-house lawyers, the executives lay down the rules and their employees simply don't follow them. So I'm going to give you a couple of examples here. Remember back to the Elliot Spitzer scandal, 6-7 years ago? And Elliot Spitzer, then governor of New York, was caught having a relationship with a prostitute named Ashley Dupree. Well, who was Ashley Dupree? No one knew. So the media organization scoured social media and found these pictures of her on her Facebook page. Now, obviously, some other photographer took them, and the way photographs work is the photographer is the copyright owner, not the subject of the photo. So there is some photographer out there who owns a copyright to that photo of Ashley Dupree. Nonetheless, as you can see on the right, the New York Times ran the article, ran the photo, thinking this was highly newsworthy. Ashley Dupree was front page news. We had to know what she looked like. And so they ran that. Another similar example, remember Andreas Lubitz, the Germanwings pilot who crashed his plane into the Alps. Once again, high degree of public interest in Andreas Lubitz. Who was he? What can we find out about him? Found that on his Facebook page. In this case, it looks to me like he's probably set up a picture of himself with a tripod, so he may be the photographer. But There may be some other one as a photographer. But again, all we know is this photograph was grabbed off of Facebook and used in a news article. Let me give you another example. This happened recently, a few years ago. This lovely lady had her wedding at a Trump golf club. And it so happened that weekend that Trump was on the premises of his golf club. He saw the wedding in the distance. He was not an invited guest to the wedding, but he decided he would crash the wedding, which he did. And some people there snapped iPhone photographs of him in the middle of the wedding reception, and that's one of them. This particular photographer only sent his photograph to two friends, or maybe one of them is a former friend. Somehow they ended up on social media. No one confessed how it got there. Pretty obvious that one of his friends, put it up there. So once it was on social media, it seemed newsworthy, and several newspapers around the country, several newspaper chains actually, took the photograph off of Instagram and ran it in their newspapers or put it on their website. All right, one more example. The Haitian earthquake a few years ago. There was a professional photographer, Daniel Morel, who was there in Haiti when the earthquake happened, and he took some incredibly dramatic photographs of the earthquake. So somehow, again, I'm not sure how, they were put on Twitter, and French press agency picked them up, and some of its client newspapers published them. Okay, so now we have basically 4 different instances of photographs being found on social media, considered to be highly relevant to the news, and used by news organizations. What does that tell us legally? Well, all the photos, were newsworthy, but in all cases, some other person was the owner of the copyright. So all were unauthorized uses of a copyrighted photograph. In the Dupree and Lubitz cases, the photos had some independent news value. There was a real need to know what these two people who were at the center of headline news look like. So there was really more independent news value there. Now, in the case of the others, and Morel, while the photos were valuable as a portrayal of the event, they weren't newsworthy in themselves. There was no reason anyone had to see Morel's photos to know about the earthquake. There were other photos of the earthquake. There was other news of the earthquake. Morel's photos did not have independent newsworthy value. So Morel sued a French press agency and said, look, I'm a professional photographer. I make money off of my photographs. You grab my photographs off of Twitter. You use them without authorization. You even profited by letting your member newspapers use them. So the news organization initially said, well, because they were on Twitter, we have the right to use them. Anybody can use what's on Twitter. Well, that's not true. Morel never gave third parties any permission to use his photographs. Even if he had posted them on Twitter, which we're not sure of, the Twitter terms would say, we, Twitter, have the right to use your photographs, but as you see on this slide, you retain your rights to any content you submit, post, or display on or through the services. So Morel still owned the rights to anything he had put on Twitter, even if he had put these on Twitter. And there was no excuse for other people to use them. And as a matter of fact, Twitter's terms even included the statement, when you put something on Twitter, you're authorizing us to make your tweets available to the rest of the world and let others use the same, like retweet, for example. But what's yours is yours. You own your content. So the court said that French press agencies' use of Morel's photos was presumptively infringing. And that case ended up with a fairly high amount of damages paid by French press agency to Morel. Now, what about the three other cases? Well, in the Hearst case, that was also litigated, and oops, that's a mistake. It says 2011 on the slide. It's 2018. I'm sorry. I don't know how that mistake got made. But that case was decided just last fall. Jonathan Otto, the photographer, took this photo. Hearst grabbed it, and the court said it's basic infringement. Matter of fact, it was about a 14-page court decision, but the court took 2 sentences to decide that it was infringement. So, what does it mean, and why were the other 2 photos different? I think the other 2 photos were different for a couple of reasons. Number one, as I said before, they have independent newsworthy value. If the cases had been litigated in those cases, the New York Times and other news organizations would have said, look, this was hot news. It was front page news. It was the top story of the day. We needed to know something about this person. There was no other source for it, nor was there time for us to track down the photographer and pay rights. It was essential to inform people to have this. I think that would have given them a plausible fair use argument, even though, frankly, fair use in copyright law is a very difficult area, and there's no assurance they would have won on that. But they would have had a better argument. In the Hearst case, and in the Morel case involving the Haitian photographs, it was really gratuitous use. There was no need to use those illustrations to bring news to people. There were other photographs available for Haiti, and there was no particular need to inform people about President Trump crashing a wedding at a golf club. So I think that's the concern here. And unfortunately, most of what I get confronted with as a lawyer are situations like Morel and Otto, where some people are trying to just use photos on social media. You find that an awful lot of people these days find a need to have illustrations. And the way they do it is they go to Google image search for illustrations, find something, and grab it. And yet, everything they grab is protected by copyright, most likely. So there's real problems with that. And and many clients, many companies have to pay a lot in damages because the photographers are onto this. And there's a whole industry of photographers and plaintiffs lawyers who go after unauthorized use of photographs grabbed from the internet. Now, there clearly is a fair use doctrine in copyright law that can cover content from the internet. I think the strongest cases are when you're using it for education, news reporting, or commentary. But just because you're in the education business doesn't mean you're going to be exempted. You have to be using it for classroom-type education, adult education training, things of that nature. If you're using it in a promotional sense to promote your entity or anybody associated with your entity, that's when we consider the classic appropriation, a commercial use that the author otherwise could have gotten licensing fees for. So if you're trying to get fair use coverage for something you grab from the internet, I think it has to be part of the story. Like if I were writing the Ashley Dupree story today or advising a client, I would say, little is known about Ashley Dupree. All we could find about her was this information from her Facebook page. Or Andreas Lubis. We don't know much about this fellow, but his Facebook page tells us this, and it's part of the story. That makes it a better chance of fair use. But you'll never have that, obviously, in the advertising promotional area. So the practical realities is the photographers are increasingly aggressive. I'm not surprised if many of you have already gotten demand letters from lawyers for photographers. Google revised its image search a few years ago to have a reverse search. So photographers are using the reverse search capability to put their photographs into the search box and find out where on the internet those photographs are being used. In addition, stock photo sites have more sophisticated digital watermarks. When something is taken from their website or their sources, they can find it through these digital watermarks. Finally, if any of you kind of grew up in the old days as I did, when you said, well, if there was no copyright notice on it, there's no copyright. That was true before 1989. Works were only copyrighted if they were first published with a copyright notice before 1989. But on March 1st, 1989, the United States joined the Berne Copyright Convention, which requires no formalities as a prerequisite for copyright protection, so that notice requirement went away. What can you do if you need to use photographs? There's one more point. The other thing about the risk here is that statutory damage is applied to timely registered photographs, all timely registered copyrights. And your typical person claiming statutory damages will demand up to $150,000 per work. That means per photograph. And it's unfortunately a kind of an anomaly in our law. If Hemingway spends 3 years writing a novel, he has one work, and maximum statutory damage is $150,000. If a photographer sneezes, he or she has 20 works during the course of the sneeze because of his or her finger on the shutter, and can claim willful infringement damages of up to $3 million because it's $150,000 per work. So this has become a real threat. All right. Now, what can you do? The alternatives to copying someone else's content are seeking explicit permission. There's no formal legalistic way to do that. You can send an email, you can do a letter, you can make a phone call. You can often get permission for free or for a minimal amount. Some people demand a lot. Those are the people who would definitely be making copyright claims, so don't use their stuff. You can also create or commission original content, which is not all that hard because everybody has cameras, and there are a lot of photographers willing to take on assignments. If you do that, be sure you get the right rights or the right permissions. And then finally, there's a whole realm of things called Creative Commons. Creative Commons is a mechanism by which some creator of copyrightable content, creative content, can designate his or her works as licensed under Creative Commons, meaning that other people can use them and only under certain limitations. All Creative Commons content requires attribution to the author. Sometimes it can be used only for non-commercial content. Sometimes it can be adapted or not adapted. There's a few other twists of Creative Commons. But that's a tremendous source of basically free content. You can go to creativecommons.org, search for different kinds of content on their website, and that's another alternative to grabbing some photographs.
So, Mark, a question for you on this. What we see with, I mentioned at the outset, a number of our institutional clients, as more and more they're being approached by, very hip, trendy, sophisticated vendors who are offering, in the ed tech space, who are offering different platforms or marketing strategies, et cetera. And sometimes these vendors come to the school and they've already got photos. And they've already got images that are part of their pitch and a part of what they're offering. Is it fair to say that schools should be interested as to where that content is coming from?
Sure. At the very least, you want warranties that they got it from licensed sources and indemnities in the case of any copyright claim. Absolutely.
And presumably if the school internally, its own marketing folks, are pulling together imagery for marketing and commercial purposes, and they're looking at, student or employee or faculty websites and things of that nature, I mean, these rules all apply.
Absolutely.
Okay.
Absolutely. Yep.
Got it.
All right. Now here's one other issue. Next issue I want to go into. This might be something that you don't think of in the case of marketing, but I get the question a lot, and the question I often get is the general counsel calls and says, hey, our CEO loves Star Wars, and he's going to make a big presentation to a company meeting, and he has worked Star Wars excerpts into his PowerPoint. He can do that, right? So the general counsel calls me because she doesn't want to be the one to tell him the bad news. I have to be the one that says, no, he can't do that. So that happened for a long time, and it's always difficult because the CEOs and the chief marketing officer and people, they're always someone who loves some movie, wants to use some movie, and frankly, I kind of understand it. Movies are our culture. This is how we communicate. Why can't we use the icons of our culture in communicating. Well, you just couldn't because those were copyrighted works. However, an interesting development has occurred. Let me tell you the story in kind of an abbreviated form. And the result is that you can use movies from the internet in presentations if you play it through YouTube. So here's how that came about. YouTube used to have lots of infringing content. So Viacom sued YouTube. Viacom had the shy retiring lawyer Donald Borelli of Den of Jenner and Block, later U.S. Solicitor General. Actually, he's not shy and retiring if you ever met him. And Mr. Borelli sued YouTube, which is owned by Google. So I call it Borelli versus Larry Page and Sergey Brin. Now, the law was pretty bad for Viacom because the law said that Google is only obligated to take down infringing content when the copyright owner contacts it specifically with respect to one specific piece of infringing content, and then and only then does it have to take it down. Burley said, well, you also got a duty to stop repeat infringers, and your whole business is repeat infringers, and you're making gazillions. The case went on. It was hard fought, and eventually Google won, I would say, 95% of the case. But Google being Google, they just didn't mindlessly defend the lawsuit. They also sent teams of people up trying to find a technical solution. What they came up with was a content ID system. The content ID system, what it does is every major studio, before they release a film, send it to Google. Google analyzes the film digitally and puts all that analysis into its database. Then, when someone infringes that film by posting it onto YouTube, Google picks it up, knows it because of its digital screening. Then Google either does not allow it to go up on YouTube, if that's what the company wants, or allows it to go up and splits its revenue with the originator. So it's an amazing system. It's a typical kind of Google, confronted with a lemons make lemonade situation. And what that means is that almost anything that you can play on YouTube is now licensed. So if you find Star Wars on YouTube or portions of it, let your CEO go ahead and play it during his presentation because Paramount or whoever that is making money on that playing, and it's implicitly licensed through the Content ID system. It's astonishing that this came out, and it's not really been publicized because I think the company still would like to control their content as much as possible. No one really wants to encourage, unauthorized uploading. But everybody, from what I can see, is following it. I was in the office of a in-house lawyer, one of these major studios a few years ago, and he just told me, the first thing that all our movies do is go to Google or, characterization under the Content ID system. So that is an out for you if you ever want to illustrate your talks with commercial movies or even commercial music, for example. You can do it without paying license fees if you go through YouTube. The one requirement is you must go through YouTube. So you're going to have an internet connection. You have to either play from YouTube.com or through a YouTube embedded player. But so long as you do that, anything you play on YouTube is presumed to be licensed. Now, there's probably some independent studios that aren't part of Content ID. There's probably some independent things, but that's generally not what the problem is. Again, the CEO wants to play Star Wars or The Godfather or one of these major things, and all of those studios are on board with the Content ID system. So that's a tip to let your CEO do what he or she wants to do, even though we used to say no. Okay, on to my last topic, user-generated content. We have a lot of user-generated content these days. Forums or message boards where people can make their own posts. A message board is pretty much all people making their own posts and replying to other posts. A forum you often see in a newspaper where individual readers comment on a particular columnist or a particular article, and they're available at the end. Photos, there's some websites that post photos or allow photos. Think of social media. Everything on social media is user-generated content. People put up their own content on Facebook, Instagram, Twitter, all those things. You may have things in your university where you have social media-like posts where you can let students or faculty or friends or whatever make their own comments or post their own little photos or pages. And then finally, user-generated content also applies when you're the internet service provider, which a university might be, and students make use of your network. So let me explain the law on user-generated content. There are two special internet laws that give special treatments to user-generated content in the context of the internet. It doesn't apply in the brick and mortars world. It only applies on the internet. So there's Section 230 of the Communications Act, that'd be 47 U.S.C. Section 230, that exempts intermediaries from content-like liabilities, libel, defamation, fraud, right of privacy, basically any kind of publication-type tort. And then there's Section 512 of the Copyright Act, 17 U.S.C. Section 512, that exempts intermediaries from copyright liabilities, but he has a little more twists and turns than the content liability exemption, which is strict liability. So let's go through these. Who's protected by them? Service providers, website operators, message board operators, social media sites. So again, think of it in terms of your university. My guess is that many universities, many higher education institutions, in some ways have some of these things. You have a website where some people can comment or put up content in some ways. You have your own message boards in some ways. You've created your own, internal social media sort where people are commenting and posting things. So in any of those situations, these type of protections would apply to you. Okay, so we'll take the first one first, content liabilities. In the brick and mortars world, all publishers are liable. I used to be a newspaper reporter. In a newspaper context, if a reporter wrote something that was libelous of a subject, the reporter could be sued. So could the city editor who edited it. So could the managing editor who authorized its publication. So could the person whose role was publisher. So could the company that published it. Any one of those was liable. As a matter of fact, even the newsstand where it's sold could be liable once they have notice of a libelous content. Online, we've wiped out all of those liabilities. It's only the original content creator and no intermediary is liable online. Why is that? Because Congress felt that in order to encourage the internet, we couldn't require every intermediary. Back in those days when this was passed, it was America Online, CompuServe, things like that. We couldn't require America Online and CompuServe to hire hundreds of lawyers to review everything before it was posted. So there had to be this freedom from intermediary liability in order to encourage the internet. So kind of to put it together graphically, in the brick and mortar world, everyone in the stream, newspaper, publisher, reporter, distributor, is potentially liable for content. But Section 230 creates a distinction between the writer-creator and everybody else, the intermediary distributor. Only the writer can be liable, and the distributor is not liable because of Section 230. Now, there's another little twist beyond that. In exempting the intermediaries from liability, Congress also said we're also exempting them from liability if they edit or try to control things. So they don't have to automatically post everything that goes up. They have what we call Good Samaritan exemption. They have every right to stop violent, obnoxious message board messages from going up on the message board. They have every right to put their own standards of suitability so that the article written by their reporter isn't necessarily followed by all sorts of wild messages with lots of obscenities. Any decision they make to take something down or even to edit it for suitability is okay so long as it does not create new content. Typical editing is fine. The only thing they would be liable for is if they become somehow a co-author with the original writer of a particular content message. So two aspects of Section 230, no liability for user content, but also no liability for editing, controlling, whatever user content.
So, Mark, if an institution does have, and let me give you two scenarios. One would be if they have their own internal platform, some social media-like site that they've created. The other might be their Facebook page. But let's say in either one of these scenarios, there are individuals, whether they be student, faculty, or just someone from the press or the public, rather, if they post something that is obscene or inappropriate or violates the institution's standards, either for its internal website or posting a page, or for, say, a Facebook page, the institution has flexibility here, because we get this question occasionally. The institution has some flexibility then to edit and take those posts down and act in that way.
Absolutely, and I think that's really important to know, because I think that what's happened, unfortunately, in the last 23 years since Section 230 was passed in 1996, is there's been this feeling in the industry, well, hey, okay, this is great. I just can let everything flow through. And you may recall newspapers until a few years ago had all sorts of really terrible stuff in their forums, because they took the philosophy, we're not liable for this, and these crazies are bringing more hits to our page, so that's great. Well, our national dialogue has deteriorated a lot, and come on, we have responsibility for our content. Why are we allowing such awful stuff on? So I think there's a renewed focus recently on using the other arm of Section 230, the Good Samaritan provision, to apply some standards. And just a few months ago, the UK House of Commons said, we are so offended by what Facebook has done that we are thinking of creating an exemption to the British version of Section 230 and saying Facebook doesn't apply to you because Facebook, you need to apply more controls. And hopefully that was a wake-up call to Facebook. Yeah, you need to apply these Good Samaritan controls, or you're going to get, you're going to lose your exemption. Same thing has happened in Australia recently. The legislature there has taken offense at a lot of this untrammeled conduit of terrible stuff.
Right.
All right, that's the content issue. What about copyrights? So again, in copyright law, all users are liable in the brick and mortar world. The writer, publisher, distributor, anyone. Copyright is strict liability. In the digital world, it's different. The writer-creator may be liable if he infringes, but the intermediary distributor has some initial obligations, but then has immunity if he solves them. So let me describe that in a little bit more detail for you. The Digital Millennium Copyright Act, Section 512 of the Copyright Act, provides a notice and takedown procedure. The first thing is, and this is important for all of you who may be hosting copyrighted content, you need to register an agent with the Copyright Office. My illustration shows the old written form. As of beginning of last year, it's now an electronic form. But it's a registration process with the Copyright Office. It's a very simple one. It used to cost $105. It costs less than that now. So very simple. You have to register an agent. Then, if a user posts infringing material on your site, and in my illustration, they're posting a a Disney character, obviously infringing character. The Copyright Office then demands to your agent, to the agent you register with the Copyright Office, that it be removed. That's the notice. Oops. Next comes the takedown. You then take down the content. That's usually the end of it. You've taken down the content, the copyright owner is satisfied, the infringer usually is not going to do anything else. If, however, the user who gets notice of your takedown demands it to be reposted, you then repost it. But at that point, the copyright owner can sue the infringer. Even if the infringer is located in another country, the infringer can sue in the district in which you are located. So that's the notice and takedown procedure. So basically, for user-generated content, those are the rules. For content risk, you should consider, as Aaron's question suggested, monitoring for suitability. There's no liability for the user-generated content that you post, but there's also no liability for maintaining your own standards. For copyright risk, what you want to do is be sure you have a registered DMCA agent, because that's a prerequisite. If you don't have the agent, you don't even have the potential immunity. The old rules apply, and you will be strictly liable for your user's copyright infringement. And then you need to follow the takedown rules carefully when a takedown is requested. So that's basically everything I have, kind of, in summary. For basic advertising law, keep accurate and fair messages. For endorsements, be sure you disclose all connections. For copyright, get the proper permissions. If you're doing video for public presentations, use YouTube, and then control your user content.
Very good. So we do have some questions. As folks who have attended other of our series know, I always like to plug here just real quickly. Again, there's the series, and I only highlight this slide. You've already seen the picture before, but on this slide, the links are active. So if you pull down the PDF of this presentation and you want to go back and look at some of the other presentations, you can. I'll also put in a plug. Next month is the last in our series, and it's going to be a charitable planning update. So we'll talk a lot about, and this will be obviously focused primarily for the public and private nonprofit side of the house, on some of the most recent trends and things that are occurring around charitable giving. Our webinars are available on demand. All you have to do is go to the site and click, and they'll pop up. That's what the site looks like. And then we do have our blog, REGucation. So if you're interested in following that, we talk about a lot of things that are going on in the higher ed space. So, Mark, we do have some questions. I'm going to intercede. I have one question before we get going. Just on the very last thing we were talking about, again, back to this issue of institutions, they are certainly within their rights, and it is even advisable or certainly appropriate to enforce their standards when it comes to what's being posted on their sites and pages. I assume it's advisable for them to have somewhere stated clearly what those standards are that they're enforcing. Is that right? Maybe not required, but useful?
I don't know, Aaron. That's a good question. It's certainly not required, and I'm a little bit worried in the due process world that once you post some standards, somebody's going to say, "Well, you edited my comments for things other than your given rationale, and therefore you violate your own standards." I think the point is, I would keep it vague. I would say for suitability, and based on our judgment,
Great.
Because that's what the law allows you. Yeah. I'm not sure I'd say sole discretion, but I would say, judgment, suitability. Suitability is a very broad concept.
Good. Very good. Okay, so we have some questions. First question. If we engage paid influencers, do we need to have a written contract with them?
No, influencers, unless there's some reason why it would otherwise fall under the statute of frauds, like some contract that couldn't be performed within a year, there's no need to have a contract with influencers. I would say that if you are working with paid influencers, I would at least have some exchange of emails or exchange of letters to clarify their obligations. That they have to be, they have to say, use the hashtag ad or hashtag sponsored disclosure. They have to, whatever they say has to be their true belief. When you have renegade endorsers, you're going to be liable and they're going to be liable, and the FTC could pick it up. So you want to clarify everything as much as you can.
Got it. And I know a lot of schools use endorsers. A lot of times those are graduates, are alumni of some import, right? And also for the folks, there are accreditors and some other education regulators that actually will have some additional requirements around the use of endorsements that you want to be paying attention to. So this is a very interesting question. It's about the Fire Festival, and maybe you can talk a little bit about that. I know a lot of folks have seen, what is it, on Hulu and Netflix, there are competing documentaries around this, and I know a lot of it's around this idea of influencers. So here's the question. Wasn't the Fire Festival's problem that it didn't deliver what it promised, not that it had so many influencers or that they didn't properly disclose their payments? Maybe just give some background on the Fire Festival.
No, good question. The Fire Festival was this festival is going to be held in the Caribbean, allegedly on an island formerly owned by Pablo Escobar, and got lots of attention. Unfortunately, the organizers of the festival really didn't have their act together as far as organizing the festival, but boy, were they good at social media promotion. And they got all sorts of influencers on board, including one of the Kardashians. They paid for that. They had a coordinated social media campaign, and only a few of the influencers actually did the right thing. Again, they had no direction to the influencers. The influencers just took the money and did whatever they did, so they violated every rule in the book. And then when the festival happened, it was a huge disappointment. Instead of being the new Burning Man, instead of being on the Pablo Escobar Island, it was on another island shared with other things. They didn't have the entertainment acts they promised. They didn't have the glamorous gourmet food they promised. They were giving half bologna sandwiches out, and it was a disaster. So yes, to some extent, the failure was the failure of the festival, but it was incredibly affected by the influencers because influencers are influential, and they brought so many more people to that event, and that's why it crashed so wildly, because the influencers were effective, as they always are, which is why we have these influencer rules.
Very interesting. And I think one of those actually, I can't remember which, if it's the Hulu or the Netflix, but one of them really focuses more on the influencer's role, I think. So I think we'll have one more question here. What is the rule of thumb for distinguishing between puffing and factual claims?
Well, good question. I'm not sure there's ever a firm rule of thumb in advertising law because, again, it all depends on viewer perception. But generally what you do is you look at, can it be proven true or false? If it's something that can be proven true or false, it's probably a factual claim. If it's just kind of a vague thing we often call rhetorical hyperbole that no one can sit and scientifically prove true or false, that's probably puffing.
Got it. Yeah, that's always an interesting question. Hey, so that brings us to the end of the hour. As always, we are so grateful for everyone who stops in. I will remind folks, we do have an evaluation that you can fill out here and give us feedback, a survey. We are very grateful for that feedback. I say at every presentation, and it's true, we always read your comments and try to make sure that the next presentation, to the extent it can be, is better than the one before. Hope everyone has a great afternoon and a great weekend coming up. And remember, we have our next and final webinar for the season. In May, we'll be sending out emails about that if you want to register, and it's going to focus on charitable planning. So thanks all. Have a great day. And thank you, Mark.
Thank you.